Call the Judiciary Committee back to order and open the hearing on Senate Bill 2321. And I did tell some of the people that what we're going to do is allow 45 minutes for those in favor and 45 minutes for those in opposition. And we're going to stick strictly to that number. So thank you. Would you please read the short title?
Relating to awarding costs and fees in eminent domain proceedings.
Hi, Madam Chair and committee members. For the record, I'm Senator Jeff Magrum, serving District 8, and I'm here to introduce Senate Bill 2321. I was having trouble with the printer up there, so I don't have any testimony to give you, but I really want to just get out of the way because there's a lot smarter people on this issue than I, and I don't want to get anybody in the weeds. So I ask you to ask your questions of the next speakers, if that's okay.
That's okay with me, unless anybody has a question for Senator Magrum. No? Okay.
Okay. Thank you.
Thank you.
Yeah, I want to make it simple for you guys. It's a good bill. Just pass it.
Okay. Thank you. Thank you. Other testimony in support of Senate Bill 2321. That goes till 3:15. Welcome to your committee room, sir.
What's that?
Welcome to your former committee room, sir.
Oh, thank you, Madam Chair. Thank you. Madam Chair, my name is David Hogue. I'm a state senator from District 38 in Minot, Northwest Minot, and, of course, part of the Minot Air Force Base. I wanted to come here and testify in support of Senate Bill 2321. And I would just point out to the committee members, you know, sort of this ongoing debate that we've had on the Senate floor concerning making sure there's an appropriate balance of bargaining power between landowners and those who seek to condemn the landowner's property for some public purpose or for some other purpose that is authorized by statute. And I think this is a good bill that the committee should support because it makes the law clear that in cases where eminent domain proceedings are commenced, for example, and then the case is withdrawn for whatever reason, sometimes public entities and others decide to that they're not going to go forward with a project or that they are going to reroute a project and they withdraw from the case, that the landowner be made whole. And the landowner can only be made whole if they get reimbursed for the expenses they reasonably incur in trying to respond to the condemnation action. And those fees, of course, are court costs, which are pretty minimal. Of course, there's attorney's fees. Most all landowners are going to retain an attorney to represent them. And in a lot of cases, the landowner is going to incur expenses for expert witnesses. And in many condemnation actions, that would be, for example, an appraiser. Somebody comes to you as a landowner, they want to condemn your property, whether it's to take the surface or to take a small part of the property rights, like an easement, where they're not taking the surface, but yet they're taking the right to access your property. And in those cases, you would want an expert witness to tell you what is the value of what the condemnor is proposing to take from you. And so I think that's a reasonable expense. I think most trial judges would think that they have the discretion to award these fees, but what this bill does is make it crystal clear that they should consider those expert witnesses' fees. I know in a federal case, one of our federal judges say, well, since expert witness fees were not mentioned, the federal court was not clear that they had that authority, and this would give them that clear indication. You do have the authority to award the landowner for the expert witness fees, the appraiser fees that they have spent in preparation for the case that they've been sued for. So that's the reason I support the bill, Madam Chair. Be happy to try to answer any questions about the bill, but I'm sure there are many others in this room that know a lot more than me.
I have one question, and that is that this then, just to clarify, is those fees are only awarded if you win, right?
No, Madam Chair. This bill contemplates that there's no jury trial. The case is withdrawn. I, as the condemnor, I may have changed my mind. It could be a transmission line where I'm not taking that route. It could be a number of different reasons why they choose not to pursue. So it addresses the situation where there is no win or loss. There is a change of mind, or there's a change of action by the condemnor.
Thank you. Senator Myrdal.
Thank you, Madam Chair and Senator Hogue. So is this sort of part of that, what should I call it, rewrite or of eminent domain that you spoke pretty passionately about on the floor the other day in another bill? Is this kind of a step towards that?
Yeah, I kind of, the senator from District 8, I kind of set myself up because I said that the answer is not to disallow eminent domain. You have to have that. If you're going to have development in your state for any type of infrastructure, whether it's railroads, highways, pipelines, transmission lines, you have to have that. We've had that since the existence of statehood. We cannot get rid of that because we don't. Well, now I'm going to have to get passionate again because I have to tell you, Madam Chair, I absolutely love pipelines. Nothing has been devised to transport liquids or gases more efficiently, more quietly, without odor, and safely. So I always will support pipelines. But that doesn't mean that the landowner shouldn't be treated fairly. And so this is just I think a pretty modest clarification to make certain that the landowner will be compensated for their expert witness fees when they're incurred at the initiation of a suit by a condemnor.
Okay. Senator Paulson.
Thank you, Madam Chair. Leader Hogue, there's a potential amendment that's been talked about that I think you're aware of, and I didn't know if you'd want to speak to it since you're here, that involves a situation where the condemnor changes their mind in the 11th hour and it affects people potentially negatively.
Repeat that again.
So a situation
11th hour, meaning
right.
What?
Well, meaning maybe they've been working on condemning the land, they've been negotiating.
Oh.
The person whose land's about to be condemned hires an attorney, gets some expenses.
Yep. Okay, yeah, I have seen that amendment. So that amendment, this bill as originally drafted contemplates a fact scenario where a lawsuit has been commenced, and by that we mean that the landowner has been served with a summons and complaint. And so there's an existing lawsuit. The amendment that I saw relates to, and this happens often. There is, before there's a lawsuit, there's the condemnor, the person looking to condemn your land, hasn't started a lawsuit. They've sent out what they call a landman or somebody else to negotiate. The landowner has listened to that. And they said, well, the typical response would be, let me talk it over with my attorney. Let me discuss it. The parties go back and forth. They might exchange, let's say, an easement agreement. And that goes on for a long period of time. And then let's say they can't come to terms. And so the question of that amendment seeks to address is, should the landowner in that fact pattern where there's no lawsuit, but yet there's been these ongoing discussions that the condemnor has initiated, in that scenario, should they be entitled to recover their attorney's fees and other potential fees? And I guess I don't have a position on that, Senator Paulson. I would leave that to the committee's discretion. That's another step forward.
Senator Castaneda.
Madam Chair, Leader Hoag, you talked about this being, in the case of a federal court. If this wasn't a federal court, would the federal court come back and look at state statute, or would they just stick with federal statute?
Madam Chair and Senator, the rules, there are rules of civil procedure in federal court that are different in state court. And the federal courts are more restrictive in authorizing the recovery of expert witness fees in all kinds of cases, not just eminent domain, but any type of case where experts are engaged. The federal courts is very restrictive. But I am aware of a federal case where the local federal judge said, "Well, you landowner, you have incurred significant expert fees, but the statute doesn't." The state statute doesn't explicitly say that you're entitled to recover those under state law. And, the federal judge in that case was supposed to be applying state law. So he looked at that and said, well, I'm sorry. And so hopefully that would provide redress for that fact pattern not reoccurring.
Thank you. No other questions, committee? Other testimony then in support. Thank you, Mr. Chairman, Mr. Leader. Other testimony in support of the bill. Just to reiterate, this goes until 3:15 for in favor.
Sorry. Chairwoman Larson, members of the committee, thank you for taking my testimony today. My name is Troy Coons. I represent the Northwest Landowners Association. We're a group of several hundred farmers and ranchers and property owners across the state. I'm here as their lobbyist. I am unpaid as the lobbyist. We are a volunteer board. The Northwest Landowners Association supports SB 2321 because it's important to ensure property owners are made whole when the government takes their property. If the amount of their just compensation is reduced by the expenses of expert witnesses and appraisals because these items are not reimbursed, then they are not truly receiving just compensation. Generally, we understand that in North Dakota, landowners get their fees and expenses included in their appraiser fees reimbursed at the end of eminent domain to make them whole. But our legal counsel has advised us that the North Dakota law is being applied in federal courts in other contexts and also in the context of eminent domain lawsuits. One example is a natural gas pipeline which uses the Natural Gas Act, a federal law that gives the developers condemnation rights. I've attached one case provided by our legal counsel in which the federal court in North Dakota applied the North Dakota law in the federal condemnation actions on these specific issues, reimbursement of these attorney fees. And that is on the back of my testimony there. And on the last 2 pages, there's some highlighted part that you'll want to review. We believe it should be clear in North Dakota law that it is part of our right to compensation that we are also able to get our expenses reimbursed, including the expenses for appraisers and other experts that are needed. We understand there are times when federal courts do not consider the expert witness expenses to be part of a recoverable cost. So we want it to be explicit that North Dakota, we intend our laws to cover that, and we intend that the landowners are made whole. So with that, this is Judge Hovland's ruling, and it's on the highlighted part I would like you to look at. I have our legal counsel, Derek Broughton, here today to talk in more clarity and specifics on how this is going in practice. And I also just handed out the possible amendment. There's been discussions of us moving that forward. Senator Hogue related to that, his thoughts on that. And so I guess I would like to leave that before the committee if you choose to adopt it or not. But we would like to see it, but we'd leave it before you. And with that, Derek Broughton, our attorney.
Thank you. Any questions for Mr. Coons? Thank you, sir.
Thank you, Chairwoman Larson, members of the committee. My name is Derek Broughton. I'm an attorney in Bismarck. I primarily represent farmers and ranchers. I do a lot of property rights and landowner litigation. I do a lot of eminent domain litigation as well, and I'm general counsel to Northwest Landowners. I want to just talk briefly about the situation that is being addressed here, and as the Judiciary Committee, you might already know some of this, but you know, generally speaking, we have our state courts and we have federal courts. Generally speaking, federal courts have jurisdiction in two general situations, either because there's a federal law at issue or because there's citizens of different states that are in a dispute. And when you have that situation in federal court where it's someone from North Dakota, for example, and a citizen from another state, that's also a situation where you can use the federal court system. Now, some of those cases, as you can imagine with, for example, energy developers and large corporations, you often end up in a situation where it's a North Dakota citizen and an out-of-state corporation in a dispute, and those disputes often end up in the federal courts. But a lot of times those disputes are state law disputes. And so one of them would be the Surface Damage Act in the oil patch, and there's another bill, 2335, that addresses that. But there's also eminent domain, and the case that is attached is a Natural Gas Act case. Now, those cases go to the federal courts because they're under a federal law, the Natural Gas Act, and so these natural gas interstate pipelines, they use eminent domain under the Natural Gas Act, but what the federal courts do is apply the state's eminent domain law. And so the federal courts apply state law in a lot of these situations. And with respect to eminent domain, for example, under the Natural Gas Act, they apply the state law on just compensation, the state law on recovery of fees. But here's the catch, and this is what Senator Hogue was talking about. When federal courts look at the issue and they look at a statute that says this person can recover their attorney's fees and their costs, or their attorney's fees and their expenses, the question is, how do the courts interpret that word, expenses or costs? And are expert witness fees considered to be costs, not in federal court? In state court, they always are. And so these same statutes, if you were in a North Dakota state court, there would be no question that you would recover your attorney's fees. No one would question that. But it does become a question in the federal courts when we have a state law that says you can recover your attorney's fees and your costs and disbursements. You can recover your attorney's fees and expenses. And then the question is, are the expert witness fees part of those costs? And that's where what the federal judges have said, in specifically federal judges in Bismarck have said, we need something explicit in the state law that says that those expert witness fees are included. Now, it's important because for a lot of landowners, I have been an attorney who's advocated for landowners being able to testify themselves without experts, because appraisers can get quite expensive. And so sometimes landowners want to go in and just say, hey, I got these other agreements, this is what I think. And I have been one of the people who's actually advocated in courts for that. It's because the landowners don't always want to hire the appraisers. But these judges have also said, you're very unlikely to win at trial, and what they're really saying is they might not let evidence in at trial if you don't have an appraiser. And so this is a situation where the landowners really do need to have expert witnesses in a lot of these cases, and in eminent domain cases, it's very rare that you don't have some kind of economic or appraisal expertise. You have a limited, but you have a limited situation where federal courts don't always grant these fees because it's not explicit in state law. One of the reasons this is also coming up now is years back there was something we all refer to as the Nick case, which overruled a prior case that opened up the federal courts to eminent domain cases. And so the Nick case also meant that we're going to see more eminent domain type cases in the federal courts. And the reason I bring that up is just to point out that there are more and more cases ending up in federal courts now as opposed to state courts. And because of that, this is a growing issue. And the last thing I would say is that, you know, I've had several cases with decisions. It sounds like Senator Hogue is familiar with these cases. But I want to repeat that in state court, this isn't an issue. The state courts already award these kinds of expenses, and they should be awarded. The other thing I've heard a couple of times from some folks asking me questions is, well, is this an issue of federal law? No, it's not. You could change federal law to tell the federal court system that you must always look at state laws and assume this, that expert fees. But that's not what's necessary here, because all the federal judges said, and what they said is we need something explicit in the state law that's being applied in federal courts. And so the solution is not in federal law. It's literally the state laws that those judges have explicitly said. I just need something explicit. And so all we're doing here is saying that just as the state courts already say themselves, when we say you can recover your attorney's fees and costs in an eminent domain action, you can recover the costs for those appraisers and your experts as well. And so that's really what this bill does. With that, I would stand for any questions.
Senator Corey and then Senator Lewick.
Thank you, Madam Chair. Mr. Broughton, could you provide a ballpark of what citizens are incurring for expert witness fees?
Chairwoman Larson and Senator Corey, yes, I can. It really depends on the appraisal and the appraiser and the complexity. But what I would say is that the average landowner side appraisal that I've seen when you're in federal litigation would be somewhere between $15,000 to $30,000 total. Now, that's not to say there aren't like if you're gonna go and just do this farmer's selling a quarter section of land and I need to look at some comparable sales to figure out what the ag value of that quarter section is, that's not a $15,000 appraisal. Well, that's a couple $1,000 appraisal. But when you're doing appraisals that take into account everything going on in the state of North Dakota, including development in the oil patch, different types of transactions that the federal courts have ruled do come in, those appraisals get to be much more complex. And so that type of a litigation appraisal that also includes the time for the appraiser not just to do an appraisal but to visit the property and come in, appear in a deposition and be interrogated and come to trial, and I'm including all of that. And so these are the kind of fees and expenses you generate when you're getting these appraisals in litigation for litigation.
Senator Lewick.
Madam Chairman and Mr. Broughton, so just going off the tail of Senator Corey's question, does the judge have a latitude to limit the amount of expenses for these procedures?
And Madam Chairman, Senator Lewick, yes, definitely. The judges, with respect to even the attorney's fees, it's always about the reasonable fees. And so the judge is always going to look at what they consider to be reasonable. And so if someone came in with a $75,000 appraisal, that better be a pretty expensive property, or they're going to have to really show their work on something like that. But generally speaking, the judges are quite familiar with what appraisals and litigation look like because they actually see them all the time. And so they've got a good sense of what reasonable expenses are, and they will limit it to that.
Senator Myrdal.
Thank you, Madam Chair. Mr. Broughton, a good Norwegian name.
Yeah, thank you.
I recognize those. Are you familiar with the amendment?
I am.
Okay, so on page 2, subsection 5, if you wouldn't mind, give some explanatory reasons for those 5 ABC subsections there.
Madam Chairman, Senator Myrdal, the amendment addresses a different situation, but it's tied to the recovery of fees and expenses in eminent domain. And I'll just sort of tell you a story of what I've seen happen as the explanation for what this is intended to accomplish. There are, in one thing I'll say right off the bat as well, is that when I'm arguing, for example, in a case, an eminent domain case, that I should recover fees for my client, if I spent a little bit of time negotiating up front, I'm going to try to pull as much of that in as I can. But the courts are always going to say, listen, if you're drafting a complaint or an answer for a lawsuit in eminent domain, that's part of the litigation. But if you're negotiating an easement, it's not. And so what can happen for landowners is a landowner might be willing to sign an easement, be willing to support the project, engage in negotiations with the condemning authority, and then 4 or 5 months down the road, the condemning authority says to their neighbor, we've got this person ready to sign, do you want to sign? And that person signs, and this person is just left standing there, having spent 20 grand on attorney's fees to negotiate an easement, thinking that they had a deal, and at the last minute they didn't. And so what happens is when we look at eminent domain in North Dakota, the idea has always been that the reason we give attorney's fees and expenses is that it's one thing that we're going to take the landowner's property. If you're going to take the landowner's property and give them market value, if they've then got to spend $100,000 to get that, that's not fair. They're supposed to be made whole. And so if they don't recover their expenses and attorney's fees, they're not made whole. You're taking their just compensation to pay the lawyers, and I know I'm the lawyer saying that, but that's not fair to the landowner. And so the idea here is that, you know, if you have an actual condemning authority come in, and they, you know, this isn't, 2 days, but if they engage in extended negotiations over 90 days, and then they back out, the idea is that they're going to reimburse the landowner for engaging in that negotiation with them to try and get to a point of a voluntary easement.
So if the judge awards reasonable attorney's fees, for example, and you're an attorney and you charge $500 an hour, and the judge says reasonable attorney's fees are $300 an hour, then does the landowner have to pay the extra $200 an hour?
Madam Chairman, that is generally between the landowner and their attorney. Most attorneys would expect the landowner to pay that difference. And what I can say just on a practical level is I usually tell my clients that almost always we're not going to recover exactly what I bill. And it doesn't necessarily mean that I'm unreasonably billing my clients, but there might be a situation where I think it's important for me to have my litigation manager and another attorney with me. And the judge says, I think you would have been fine without that other attorney. Well, I can honestly say to my client, I think it was better with the other attorney and I think you got value, but the judge disagrees. And so that's a situation where a judge might say that's not reasonable. But you're also right that sometimes judges will just say your rate's not reasonable. It should be not 500, it should be 400. That's what the landowner recovers, and then as between that difference, that's between the landowner and their attorney.
And so they're not made whole no matter what the expenses are, just necessarily. I mean, it might be less and the landowner still loses depending on how much the judge awards. The judge has some latitude.
And Madam Chairman, I think that conceptually and generally speaking, what you just said is accurate and correct. I think that the give or take there, though, is in the range of a few percent. And so landowners are going to get some small discounts, but usually you're not going to see, a discount where it goes from like 500 for a rate down to 300 for a rate or something like that.
Okay. Any other questions for Mr. Bratton? Thank you, sir.
Thank you.
Other testimony in support of 2321?
Madam Chair, and committee members, my name is Travis Zablotny from Minot, a farmer and landowner. Actually didn't come here to intend to testify on this, but I can offer one thing, and that is a face to a person that this bill would directly have impacted had it been law prior. My father and I own a parcel of land west of the Minot Air Force Base that the Enbridge Sandpiper pipeline was to traverse. And we ultimately, in their initial offering, were not content that they were offering what the property was worth ultimately, or the easement was worth, and so we did hire an attorney, negotiated for a long period of time with them. And what had happened over that period of time, and this is where the actual amendment makes a lot of sense at the moment, was during that period of time that we were negotiating, the viability of their project went out the window because Minnesota was standing in their way of making it happen. And so in the end, as it turned out, we did have a verbal agreement by email on a final settlement, but it could easily turn to the point where they said, well, no, we don't need it anymore. And I would have had dollars invested in an attorney to get to that point, fairly substantial, and just in terms of defending, what I thought was the right value for that easement. So it does in fact happen, and that's the only reason I'm standing before you at the moment, is to tell you that I dealt with this situation in real life. So,
Any questions for Mr. Zablotny? Thank you, sir. Is there other testimony in support of 2321?
Madam Chair, committee members, my name is Gerald Gorick. I'm from District 2. I'm chairman of District 2. I stand here in support of this bill, clearly on the fact that this bill shouldn't even be an eminent. This bill strictly mainly goes on the carbon CO2 pipeline coming through that the people don't want. This shouldn't even be an eminent domain decision, because that pipeline should never be under an eminent domain possession. You have a foreign adversary who's highly invested into this pipeline coming through North Dakota. There should be no dollar amount that is limited to what they pay the landowner for their land. If somebody doesn't want to give up their land, they shouldn't have to give up their land in this case. That dollar amount should be limited. And to pay attorney fees, they should have to pay every attorney fee that ever existed from the start of this thing from 2-3 years ago to the end date of it. There should be nothing that the foreign adversaries don't have to pay on this, because they shouldn't even have the right to be invested in this pipeline in the state of North Dakota, as far as I'm concerned. Thank you.
Thank you, sir. Other testimony in support of 2321?
Chairwoman Larson, members of the Senate Committee, my name is Gregory Demi. I am a resident of the Minot area. For reference, I am a district chair of the District 3 Republicans, and I've also been a landman in North Dakota for the last 13 years. Part-time for the last 3, full-time for the previous 10. And like Mr. Zablotny, I was not intending on testifying about this, but in hearing this bill, in hearing the testimony, I can also add one piece of information, that as I have spoken to landowners, I'm not representing any particular company, not representing any landowners. I'm not a landowner in this setting myself, but I have talked to landowners all over North Dakota. And one thing that I would add to the testimony that's already been said is that there is a lot of landowner fatigue in North Dakota about projects. All that is to say is that when a project comes through, whether it's a pipeline of whatever, natural gas, oil, carbon dioxide, whether it's a transmission line of electric, any of these projects, although there are not official corridors where they go, there are corridors that make sense topographically and for all other reasons. And so what happens to landowners is they get project after project after project after project coming through. And they might spend money on an attorney, turn around and have to do it again and again and again. I talk to landowners all the time where they say, you're literally one of 8 landmen I'm talking to on projects right now. I can't even keep you guys straight. And then when it comes to appraisal costs, they might shell out money for an appraisal. 2, 3, 4, 5 years later, they have to do it again, because we know that costs and value changes. And it changes as quickly as you can almost bat an eye. So they might have to turn around and do it again in a few years. So as a landman representing myself and what I see of landowners in North Dakota, I would support this bill. And I'll answer any questions that I can.
Do you have a question for Mr. Denny?
Madam
Senator
Chairman,
Lewick.
Madam Chairman, and Mr. Demi?
Demi, D-E-M-M-E, yes, thank you.
Thank you very much. Mr. Demi, so you were talking about landowner fatigue. Have you ever seen a case where they seem to have one guy that comes after you, then he tires out, then the next guy, they send another guy, and another guy, and another guy?
That's not
Like a
been
second and third?
Yeah, that's not been my personal experience, but what it often is project after project after project. So not so much on the same project. There might be a case in a situation where maybe they've sent out a landman with less experience, and they all of a sudden they realize this landowner is a lot more savvy than I'm capable of handling, and they might get a more experienced landman. But generally speaking, it's just more project after project.
Any other questions for Mr. Demme? Thank you, sir.
Thank you.
Any other testimony in support of 2321?
Good afternoon, Committee Chairwoman Larson. My name is Delvin Bain. I'm landowner / rancher and also district chairman for the 33 Republicans here to the northwest. And I would say that I grew up just northwest here of Mandan, and there is a main line that feeds power into this state of North Dakota that was built in the 1950s that ran across my grandfather's land. And that was, I think it's called the WAPA line, and it is the main transmission line for North Dakota that brought power back in the 50s and 60s. And my grandpa spent considerable amount of time fighting against it because of undue compensation, and they pretty much ended up taking that land from him because, again, it was for the greater good of North Dakota, which I understand, but with that, he spent tremendous amount of time, money, and resources trying to get just compensation for that parcel of land that literally ran, it's about 400 yards from his home, and ran right through his farmyard. And he took that to the grave with him as far as the heartache and the bitterness because of that fight. And, this bill and this amendment would, again, help support those people that go through those things and take some of that burden, so to speak, that's on them. And so, again, I would support in favor of this bill and of this amendment because firsthand it passed through 3 generations of our family. And it was a story told a lot at Christmas, and again, it wasn't a pleasant one. So I would support in favor of it, and I would stand for any questions.
Any questions for Mr. Bain? Thank you, sir.
Thank you.
Any further testimony in support of 2321? Is there any online? Okay. Then we will hear testimony in opposition.
Good morning, Madam Chairwoman, members of the committee. My name is Stephanie Ingebretson. I'm appearing on behalf of the North Dakota League of Cities in opposition to Senate Bill 2321. I want to note that cities don't use eminent domain very often, but when we do, it's for, we really need to use it. The main example that was given to me by my cities was using it for flood control projects. As I think most of the people would expect, we try to work with landowners as best we can to negotiate fair deals and to pay those costs associated with getting them representation for that. But I think the way Senate Bill 2321 is written, we have some concerns that it impacts the way we're currently doing business. First, in Section 2 of the bill, on page 1, line 18, the bill strikes the language that the court may award in its discretion costs to defendants. The way I understand this has been interpreted in courts is that in most instances, defendants are being awarded attorney's fees and costs, including expert witness fees, because we're in state court. But sometimes if a landowner is not awarded more than what they were offered in their final offer, they might not award those fees and costs. So we're concerned that If that language is struck from the bill or from the language of the statute, there will no longer be an incentive for parties to work with us on these particular cases, and everything will go to litigation because they are guaranteed to get fees, attorney's fees, and costs if they go to litigation. The other concern we have with relation to how this is drafted is that it just says that they're awarded expert witness fees. There's nothing that says they have to be reasonable expert witness fees. Similar to the attorney's fees, there's an analysis that the court can do related to reasonable attorney's fees. We believe that same analysis should be available for expert witness fees. I think by and large, most of those expert witness fees are going to be reasonable, but we feel like we need the protection in the event that there is not. So in its current form, we would urge a do not pass on Senate Bill 2321, but I've outlined our concerns with the way it is drafted, and with that, I would stand for any questions.
Senator Myrdal.
Thank you, Madam Chair. So, Ms. Ingebrigtsen, so, excuse me. So with those concerns, if they were corrected, if some of that was clarified, where would the League of Cities stand, do you think? Is this a process we can work on to get the core issue sort of accomplished here?
Madam Chair, Senator Myrdal, it's my understanding that there are ways that this could be amended that would address our concerns.
Thank you.
Thank you. Any other questions for Ms. Ingebrigtsen? Thank you.
Thank you.
Other testimony in opposition to 2321?
Good afternoon, Chair Larson and members of the committee. For the record, my name is Andrea Fennig, and I'm Vice President of Government Affairs for the Greater North Dakota Chamber. GNDC is North Dakota's largest statewide business advocacy organization, with membership represented by small and large businesses, local chambers, and trade and industry associations across the state. And we're here today to oppose Senate Bill 2321. Our members support a business-friendly regulatory environment that's consistent, efficient, cost-effective, and promotes investment in infrastructure. While private negotiations with landowners are the preferred method for acquiring necessary easements or property rights for public projects, we recognize that mechanisms such as amalgamation and eminent domain, when used appropriately, are essential to ensure the continued development of North Dakota's infrastructure. By allowing the court to award expert witness costs, we risk increased costs that will ultimately be paid for by the public. We believe the existing framework for eminent domain is already balanced, providing protections for landowners while allowing for the necessary development. The proposed changes could disrupt that balance by shifting too much risk and cost onto the public entities responsible for providing essential infrastructure, services, and utilities. These changes could ultimately harm the very individuals and communities the bill intends to protect by reducing the ability to undertake critical development projects in a timely and cost-effective manner. I would just mention that North Dakota is the most freight-dependent state in the nation, and so infrastructure truly is vital. Smart approaches to infrastructure are vital to ensure that North Dakota has what it needs necessary to support and grow a thriving economy, and I'll stand for any questions.
Any questions for Ms. Fetting? Senator Paulson.
Thank you, Madam Chair. Ms. Fettig, so can you help me understand how the public is going to end up paying these costs?
Mr. Chairman, and I'm sorry.
It's okay.
And Senator Paulson, when you think about infrastructure, those costs go on to the users. So when you're thinking about roads, bridges, those costs go on to all of the residents and property taxpayers. When you think about transmission lines and utility lines, those go on to the ratepayers.
Okay, may I continue?
Continue.
So we've heard testimony that the federal judges would like more clarity in state law, that they're willing to award these fees, expert witness fees and attorney's fees, but they need to see that in state law, and it seems to me that this bill would accomplish that. Can you see the value in that?
Mr. Chairman, I'm sorry, I did it again.
It's a long day.
Senator Larson, my understanding is actually that there is some references in current statute that provide for expert witness fees.
Okay. May I continue?
Yes,
So
continue.
just one more real quick. Do you concur with the concept that when a landowner has property taken from them by eminent domain, that they have a right to be made whole?
Madam Chair and Senator Paulson, I would say that I think that the current system that we have does have protections in place. And I would just ask the committee as we have these conversations to think about the importance of balance, of encouraging those private negotiations to occur.
Thank you. I'll explain why we laughed. We have a rule in here that if the phone rings from one of us, because we know better, then we have to bring donuts for the whole committee the next meeting. And so your phone rang, and we kind of all went, donuts. Senator Lewick has a question for you.
Madam
Thank you.
Chairman and Ms. Fenning, you are aware, I would think, of the, let's say, the gross income of some of these projects that go through the state. What kind of return do you think that those companies that put these transmission lines in should acquire? What kind of gross income is nominal? What kind of even a net income that they should be expecting from a large project like some of these projects? Do you have a clue of some of that stuff?
Madam Chair and Senator Lewick, I'm sorry, I think you're giving me more credit for knowledge that I don't have. I really don't have information about rate of returns or anything like that.
Okay.
But if I could just say, I think that from what I've heard from some of the conversation today, some of the concerns are really geared towards specific type of infrastructure. And if I'm understanding the bill correctly, this bill really applies to all infrastructure.
If I may continue, Madam Chairman. The reason I bring that up is because I've sat here quite a few sessions, and I hear through the session floor and different projects that I go through, and it typically is about a 4-year return on any of these projects. That's where they're balancing out their budgets. And I know from a fact that some of the one project that come across our own land years and years ago, back in the 70s, took 4 years for that project to be balanced out. So when you talk about these landowners not becoming whole, I have a hard time I don't really see the sympathy that, or have the sympathy for the projects if they are only in it for their investors. So I'm having a hard time gnawing at some of this stuff that is thinking that we need to be so ingrained in making sure that we don't pay the landowners for their right to their property. Go ahead and correct me where I'm wrong, please.
Well, Madam Chair and Senator Lewick, I'm not sure that there's a question in that, but just a few thoughts that I would say to that is that I think, again, we need to be mindful that this particular bill, I really think, impacts all types of infrastructure across the state, which is really vitally important to so many, not only of our own industries, but also, I think, to the citizens of North Dakota. And I think that those costs are borne out by the users of all of that. And I would go back to my previous comments that when those negotiations, and I understand your concern. However, I would say that when we can encourage those negotiations to take place without utilizing eminent domain, I think that that's preferable. And so there just needs to be balance to make sure that we're not disincentivizing those private negotiations to take place.
Thank you.
Thank you.
Thank you. Other testimony in opposition to 2321? Other testimony in opposition to 2321? Is there neutral testimony for 2321? Hearing none, we'll close the hearing on 2321. Committee, we have some other obligations this evening, and so I think that we're going to hold off taking action on this bill until next week when we have our committee meeting again. And we are meeting on Monday morning at 10. So for now, we are adjourned.